Remedies of breach of contract. What initially breach of contract mean? Just breaking the rules of the contract. So let's go to the description. A formation of a contract results in creating contractual obligations between the parties. Yes, these contractual agreements are to be fulfilled with the parties on the due date as per the terms and conditions of the contract. When the party does not fulfill his obligations or refuses to fulfill it or disables himself from fulfilling it, it is known of breach of contract. Yes, instead of fulfilling all the rules and regulations or what products he must be delivering, etc., depending on the contract, he must be obeying all the rules and conditions. And if he not go or follow or proceed according to these rules and conditions, this is called a break of rules or breach of contract. Next, let's see how many types are there. It's actual breach and anticipated breach. It's a so simple thing. Here in actual breach, this contract takes place when the promisor fails to perform his obligation or refuses to so on the due date of performance. So this is on the due date of performance he fails to do it. What anticipated breach means? This is a this contract the promisor either refuses to perform or makes himself unable to perform a promise before the due date. Before the due date. Here actual due date is not yet completed. Anticipated breach of contract takes place before the date of actual performance. Before the date of actual performance. Okay, let's go with remedies. Initially, it was with a rescission is a one remedy. When party makes breach of contract by not fulfilling his obligations, the aggrieved party means the party which suffered by any types of loss. Okay, the aggrieved party has a right to rescind such contract. To exercise this right, the aggrieved party has to file a suit for the rescission of a contract. He must be filing a suit for rescission of a contract. On granting rescission, the aggrieved party gets released from his obligation on the contract. He is no more liable to perform his promise. Yes, okay. This is a lawful procedure to filing a suit suit for rescission of a contract. Next, suit of damages. On making breach of contract by the party, the aggrieved party may suffer monetary loss. In the event of breach, he may be put in disadvantageous positions or in a position of discomfort. In such cases, the aggrieved party has a right to claim for the compensation. So, if the loss occurred in terms of money or money or some products wasted or something, etc., he must be claiming for compensation, right to claim for compensation, and suit for specific performance. When breach of contract takes place, an aggrieved party suffers a loss. This loss may be such a nature that damage granted for these type by court are inadequate. It is because such losses cannot be measured in terms of money. Okay. Which losses cannot be measured in terms of money. In such cases, the aggrieved party is entitled to claim the order for the specific performance. Yeah, this is about suit for specific performance. Suit for injunction. In a contract, if a party has made a promise for not doing something, and party takes a breach of contract by doing that thing. Okay, I promised, like in the contract, party A promised that I will not be doing these kind of things, and he will be breaking the rules and performing the same thing. To prevent such party from doing that act or order of injunction may be claimed by an aggrieved party. It is an order passed by a court of law directing upon the party and refraining him on performing what he had promised not to perform. Yes, an injunction is a preventive relief which is provided to an aggrieved party where damages would not be an advocate relief. So, damages cannot be given back by that other party. So, it is a negative form of order for specific performance. Suit upon quantum merit. If a contract may be in the process of performing his promise before he completes it, the promise makes a breach of contract. Okay, contract may be in the process of performing his promise before the completed. The promise makes a breach of contract. Quantum merit is a Latin dictum which means as much as end or merit. That means And the quantum aggrieved party can also claim for the reasonable cost of work done by him in the contract. See, this is about remedies of breach of contract. Initially, it was defining what a breach means. It's just breaking the rules and not following the terms and conditions according to this concerned contract. So, how many types of breach of contract may be there? It's actual and unspeakable. And our main topic is about how to deal with this. Means the remedies: rescission, suit of damages, suit for specific performance. Initially, if the rescission, if the party is not feeling comfortable with these obligations or something, then he can rescission from the take a right suit for the rescission, and no more. If the rescission is granted, he will be no more liable to perform the promise. And for the suit of damages, if the damage occurs in terms of money that is measurable, he can claim for the compensation. If the suit for a specific performance, if the quantity is not measurable, damage is not measurable, he can be going with a specific performance. Next, suit for injection. The other party is promising that he may not be performing that thing or doing something, but he perform by breaking this contract rules. Then injection, right? Suit for order of injection may be useful here, but only the one thing negative here is that the damage cannot be like given for the aggrieved party. Suit upon quantum merit. Yeah, quantum merit, that means as much has earned or merited. It depends on the reasonable cost of work done by him in the contract. Okay, this is about remedies breach